So today during the webinar, myself and my colleague Emily Alkfist discussed the New York Limited Liability Company Transparency Act, which goes into effect on January 1st, 2026. Now, while there's plenty of time to prepare for this new filing requirement, we wanted to flag some available exemptions during our discussion. Now, namely, the LLC Transparency Act exempts most LLCs whose ownership interests are controlled or wholly owned, either directly or indirectly, by one or more entities that themselves qualify for certain exemptions under the Corporate Transparency Act, so the federal law. What does that actually mean? Most LLCs which have a nonprofit parent, so for example, like a 501c3 organization, will be exempt from the reporting and disclosure requirements, though there are some exceptions which we discuss in more detail. However, unlike the Federal Corporate Transparency Act, an initial filing is required to establish this exemption, and subsequent annual filings are required to maintain the exemption going forward. So how should you prepare? With the Federal Corporate Transparency Act up in the air right now, with some injunctions that have been filed, it's unclear what's going to happen over the next 11 months prior to the effective date of New York's own law. But for right now, we're advising parent nonprofits to review their org charts to determine if they have any active LLCs which might need to file for exemption, or if there's any inactive LLCs which they may want to dissolve and wind up prior to the January 1st effective date.